Hi, my name's Alex Bagnall. I'm the Technical Manager at Total Legal Solutions. In this short video, I'm going to go through the process of applying to revise a cost budget after a cost management order has been made. So as most of you will know, cost management has been with us in the rules proper since 2013. And before then, there were pilot schemes which dealt with the same kind of processes. But despite that, it's not been until relatively recently that we've had some formal rules which deal with applications to amend cost budgets. The first of these that we need to consider is Rule 315A1. This rule says that a party must revise its budgeted costs upwards or downwards if significant developments in the litigation warrant such revisions. Now, I've highlighted a number of words in this slide. The first is must. The rule is clear that this is mandatory. If there has been a significant development, parties are under an obligation to make an application to revise their budget. The second is upwards or downwards. The obligation to revise a cost budget isn't restricted to circumstances where the budget needs to be increased. Parties are required to apply to revise budgets downwards if there is a development which means that the costs are going to be lower than what were originally anticipated. Third are significant developments. This is the threshold, the test for whether a budget can be revised. And then finally, those significant developments have to warrant the revision. Rule 315A2 says that any budgets which are being revised must be submitted promptly by the revising party to the other parties for agreement and then subsequently to the court. So there is a requirement for promptness in order to revise budgets, and then the budget which is to be revised has to be submitted to the court even if one's opponent agrees to the revisions. The rule goes on to say that the party who's revising the budget must serve particulars of the variations which are proposed on every other party using the form prescribed by the practice direction, and that form is precedent T. The particulars of the additional costs which are being occasioned have to be confined to those occasioned by the significant development, and the party who is revising their budget has to certify in the form again prescribed by the practice direction that the revisions aren't included in any previous budgeted costs or any previous variations. So this has to be an entirely new significant development, not covered by anything anywhere else in the budget. Rule 315A4 goes on to give a little more detail about how the application should be drafted. The revising party has to submit particulars of the variation promptly to the court, along with the last approved or agreed budget and an explanation for the points of difference if they have not been agreed. Rule 315A6 corrects an anomaly which arose out of the way in which courts were dealing with applications to revise budgets before these rules existed. There was a period where courts were refusing applications to revise budgets where the work which was the subject of the revision, or some of that work, had been done before the application was made. And the reason for this was that the courts were saying that cost management is a prospective exercise. So if any work has been done in relation to a variation which was not covered by the original budget, then that would not form part of the prospective budgeting, and therefore it could not be subject to a cost management order which was revised. Rule 315A6 makes it clear that this is not the correct legal position. Provided that the work which is the subject of the revision is to be done after the original cost management order was made, then that work can be part of the revised budget. Okay, so let's look at what a precedent T looks like. The precedent T is 2 pages long. On the first page we have a spreadsheet format, a table, which sets out in the first column the work done, the different phases in the cost budget. The second column includes the current budget, so the costs which were incurred and then the costs which have been budgeted for. The next column deals with the variation. Now, the variation in this column is the amount by which the budget is to be varied. The total proposed revision for each phase comes in the subsequent column, and then finally there is a column which is completed by the court after the application has been dealt with, in which the figure which is to be allowed in respect of each phase is completed. The second page of the Preston T, again as the first column, has the different phases. The next columns along include the variation amounts, but this is in a little bit more detail than what's on the front page. So this includes the disbursements and the profit costs. And remember, this is the amount by which the budget is to be varied, not the total amounts which are going to be sought. The next column along is the aggregate amount of the profit costs and disbursements which are sought as a variation. Then after that we have some room to explain what the significant development is. Now the guidance note suggests that this should only be completed if the variation sought is more than £10,000. I think in reality, in practice, every variation sought is probably going to be more than £10,000, otherwise it's arguably not going to be a significant development. So you don't need to go into a huge amount of detail in this column as to what the significant development is, but there needs to be enough information in there in order for the court to form an overview of what the application is going to be based on. Next is what the paying party offers in respect of these variations. It may be that the paying party offers nothing, the paying party might agree to the full amount, or the paying party might allow somewhere in between nothing and the full amount. And then after that, there's room for the paying party to explain why it is objecting to the revisions, if indeed it is going to object. The test for whether a budget should be revised is that there has been a significant development. If there's no significant development, there can be no revision. Despite cost management having existed for the best part of a decade, there's relatively little authority on what a significant development is. In Sharp and Blank, the senior master gave some guidance on significant developments. He said that significant developments are fact-specific and context is important. So the court has to have regard to the size of the claim, the complexity of the matter, and the manner in which the claim has unfolded. He also said that the amount of the additional expenditure is important, but it's not necessarily determinative. Similarly, he said that one event might be a significant development, or a series of smaller events might be a significant development. On the other hand, one big event might not be a significant development, nor might a series of smaller events. And finally, he said that it's helpful to consider whether a development is significant by reference to phases, but the test is whether, as a whole, the development is significant. In Thompson and NSL, the High Court agreed with the Chief Master that a significant development might be one specific event, or it could be a collection of factors. The court also went on to suggest that an increase in the value of the claim is not necessarily a significant development. In this matter, the claim was pleaded at £150,000 and ended up being repleaded at almost £4 million. And finally, the court made it clear that the bar for a significant development should not be set too high. The rule makers clearly envisaged a situation where there could be a development which occurs which requires the budget to be looked at. And by setting the threshold too high for significant developments, the court could thwart the intentions of the rule makers. So what are significant developments? Well, there's rather more authorities out there which deal with what are not significant developments. It might be thought that this is reflective of the judiciary's view that once a budget's been set, unless there's some extreme and unpredictable event, then that is the budget that the party's going to be stuck with. In Murray and Neil Dowman architecture, the court made it clear that simply making an error in the original budget is not going to be enough to satisfy the significant development threshold. Now, interestingly in this case, the court did revise the budget, but this was a case which went through the pilot scheme where people were finding their feet, and the court made it very clear that making simple errors in the future will not be enough to get over the significant development test. In Yo and Times newspapers, the court concluded that a change in the law was not a significant development because it was a development which was outside of the scope of the litigation. In Gregg and Lachlan, a budget was prepared without the person who drafted it picking up the phone and asking counsel what they intended to charge. The budget was approved by the court, but when counsel came to be instructed, the amount which was allowed for counsel's fees proved to be far from adequate. an application to revise the budget was made, and whilst the court concluded that the amount of additional costs which were being sought was significant, it observed that this is not the test. The test is whether there's been a significant development in the litigation. And in this case, the development was simply the decision to instruct counsel who were not willing to work within the confines of the budget, and that could not be considered to be a significant development. In Seekings and Moores, the High Court made it clear that an application to revise a budget is not an opportunity for a second bite of the cherry. If there has been no significant development, then the application should fail. In Sharp and Blank, the Chief Master made it clear that if there's been a development which leads to a proportionately modest increase in expenditure, then that should not be treated as a significant development. So, for example, if a phase has been approved at £100,000, an additional £10,000 in that phase would probably not be significant. But if the phase was only approved at £15,000, a need to spend that additional £10,000 could be significant. The Chief Master also identified that simply failing to appreciate what's going to happen in the litigation, again, will not be a significant development. The classic example of what is a significant development arose in JSC and Viktorovich. In this matter, there were additional days in court required, and the court agreed that that was a significant development. In Al Najjar and the Cumberland Hotel, what started as a personal injury claim suddenly took on a life of its own. The level of disclosure which was required was far higher and far more complex than anybody had envisaged when the budget was drafted. And back to Sharp and Blank, where there was additional disclosure which wasn't anticipated, expert evidence was served which wasn't predicted, and where there was a retimetabling required as a result of the additional disclosure and expert evidence, that was concluded to be a significant development. Of course, an application to revise a budget is not the only opportunity to get away from the shackles of the cost management order. At the end of the case, on detailed assessment, the cost judge has the power to depart from the budget if there is a good reason to do so. However, parties should be very cautious about relying on the good reason provision as an alternative to making an application to revise, because as the Chief Master observed in Sharp and Blank, if there is a significant development, if the rules regarding significant developments are engaged, then it is not open to a party to choose whether to make the application to revise or alternatively to take the chances in front of a cost judge. If there has been a significant development, an application to revise must be made. I hope you found this short video useful. If you've got any questions at all about anything that we went through today, please don't hesitate to get in touch.